Imagine opening your mailbox, tearing open an envelope, and staring at a financially crippling bill for nearly $3,000. And the craziest part, the corporation that sent it is demanding you pay to fix something that was literally just broken by time itself. Welcome to our explainer on the case of the rusty Volkswagen and the €3,000 bill. It's a crazy story about how a simple, everyday transaction spiraled into an overwhelming legal nightmare. A dispute over a rental car. Honestly, it sounds like an incredibly common, simple situation, right? People rent cars all the time. But before we get to the final legal outcome, we really need to establish exactly how things escalated to such an extreme level. This crushing demand was received by a guy named Liam from a corporate car rental company. For an everyday guy already having a tough time, this is a heavy, heavy emotional blow. I mean, it's the kind of letter that makes your stomach just drop. You break out in a cold sweat wondering how on earth you're going to scrape that kind of cash together. So, how did Liam end up in this specific mess? Well, the sequence of events is honestly a very human one. Back in April, Liam signs a long-term lease for a vehicle. But by the summer, things take a turn. He hits a rough patch financially and starts missing his monthly rental payments. The corporate machinery kicks right into gear, and by September, the company legally terminates the contract and repossesses the car. So now Liam is out on the street without a ride, already struggling to make ends meet, which makes what happens next feel even more devastating. Now, at the center of all this drama is the vehicle itself. And we are talking about some brand new luxury sports car straight off the dealership lot. No, Liam was renting a 2009 Volkswagen, a 15-year-old vehicle. Keep that specific age in the back of your mind as we go forward, because it really makes you question how a nearly €3,000 bill could possibly be generated for such an aging piece of machinery. Okay, so when the company took the car back, they performed this super detailed inspection. The repossession report notes that Liam drove the car roughly 14,000 kilometers. It also lists some genuine actual damage. The driver's side door won't open from the outside. Totally fair to document that. But then they write down something else. Rust around the perimeter of the vehicle. Just rust. Natural corrosion on an old car. The corporate rental company tallied everything up and sent Liam that devastating bill we talked about. When we look at how this overwhelming demand actually stacked up against him, they wanted the missed rent, which, makes total sense. But the absolute biggest chunks of this massive bill came from two very specific areas: extremely heavy contract penalties and highly aggressive repair demands. First, they hit him with this massive number, €1,852.97. This was an early termination penalty. Because Liam stopped paying before his minimum term was up, the contract allowed the company to charge him a severe penalty equal to 7 months of rent. It's incredibly harsh, putting a massive burden on someone who's clearly already struggling, but it was printed right there in the binding contract he signed. But then we get to the most shocking line item of the entire bill, €484. Now, you might think, oh, was that to fix the broken door handle? Nope. That repair only cost about €66. This nearly €500 demand was explicitly for repainting the front and rear bumpers and the rear fenders. Why? Simply to paint over the rust on this 15-year-old car, which naturally leads us to ask, can a company actually make you pay to restore a rusty, aging car? Are you really responsible for returning a decade-and-a-half-old piece of metal in pristine cosmetic condition after driving it around for months? It feels like an absurd rust tax, penalizing Liam for something entirely out of his control, essentially making him foot the bill for the car simply existing in the real world. The court did not focus on emotion. It asked one key legal question: who pays for the inevitable cost of time? The court had to step back from the aggressive corporate billing and objectively decide who legally bears the financial burden when a mechanical object simply gets older. To answer that, the judge looked at the concept of natural wear and tear. In legal jargon, it's often referred to as amortization, but it translates to a very plain English reality: everything breaks down eventually. When you rent a physical object out, you cannot possibly expect to get it back without some level of deterioration. It is an unavoidable fact of physics. You don't expect a rental tool or a leased apartment to look brand new after a year of use, and a car is absolutely no different. Consider the stark contrast here between what Liam is actually at fault for versus the simple passage of time. The broken door handle, that is actual damage. It requires a specific repair for a specific incident that happened while Liam had the car. But rust on the metal fenders? That is natural wear and tear. Metal corrodes. That is literally just what metal does as time passes, especially when it's exposed to the elements. The judge specifically pointed out the 14,000 kilometers that Liam drove, Think about it. When you put an aging 15-year-old car on the road for that kind of distance, it is naturally going to be exposed to rain, wind, road salt, dirt, the whole shebang. The court reasoned that there is no abnormal way Liam could have maliciously caused this car to rust just by driving it. The corrosion was a direct result of normal, expected use. And this brings us to a really powerful piece of logic from the judgment. The court ruled that the lessor must expect that a mechanical device's condition will change over time. Basically, the court is highlighting that companies renting out cars for profit absolutely must accept the technical risks of aging metal. They simply cannot expect a perfectly preserved time capsule. The court applied a straightforward step-by-step logic here to protect consumers. Step 1, renting creates profit for the company. Step 2, vehicles naturally age and lose value. Therefore, step 3, the cost of that time, the rust, the wear, is a corporate risk. The business assumes that specific risk to make their profit. They're legally barred from passing the cost of natural decay onto the everyday renter. But wait, what about the broken contract? Actually, we have to pivot back to Liam's actual responsibility here, because he still technically broke his lease by not paying his rent, and he did physically break the door handle. The court recognizing the time causes rust doesn't mean Liam just gets a free pass on his valid legal obligations. So here is what the court decided Liam actually still owed. He doesn't get off scot-free. Because he signed the contract and breached it, he is still fully liable for that heavy early termination penalty, his unpaid rent, the debt recovery fees, and of course, the €66 to repair the door he actually broke. Which brings us to the final court-ordered adjusted amount, €2,970.15. Now you might hear this and think, wait a minute, that is almost exactly the same as the original €3,000 demand. And honestly, you're right, because Liam lost on the massive contract penalties and the unpaid rent. A large portion of the rental company's court and legal fees were added to his total. But here is the massive triumphant victory hidden inside this final number. That absurd €484 charge to repaint the rust, it was entirely thrown out by the judge. The company tried to tax him for the passage of time, and the court firmly said, no way. Ultimately, the story of this rusty 15-year-old vehicle leaves us with one powerful, broader takeaway about responsibility and risk. You can be penalized for breaking a contract, but you cannot be billed for the passage of time. The law will hold you to your promises, for sure, but it also protects you from bearing the inevitable cost of a corporation's aging assets. One decision changed everything. Watch the next case right here, and subscribe for more real stories.